To order. So welcome to meeting number 65 of the House of Commons Standing Committee on Public Safety and National Security. We will start by acknowledging that we are meeting on the traditional unceded territory of the Algonquin people. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. And therefore, members are attending in person in the room and remotely using the Zoom application. With regard to a speaking list, the committee clerk and I will do the best we can to maintain a consolidated order of speaking for all members, whether they are participating virtually or in person. So pursuant to the order of reference of Thursday, June 23, 2022, the committee resumes consideration of Bill C-21, an act to amend certain acts and to make certain consequential amendments to firearms. I will now welcome the officials who are with us once again. Welcome. It's always good to see you. From the Department of Justice, we have Sandro Giamaria, Counsel. We have Phaedra Glushek, Counsel, Criminal Law Policy Section. From the Department of Public Safety and Emergency Preparedness, we have Rachel Mainville-Dale, Acting Director General, Firearms Policy. From the Royal Canadian Mounted Police, we have Rob Daly, Director, Strategic Policy, Canadian Firearms Program, and Kelly Paquette, Director General, Canadian Firearms Program. Thank you for joining us once again today, and your participation is, of course, crucial to our deliberations. I will now invite Mr. Julian to the floor, or to have the floor, please.
Thank you, Mr. Chair, and I don't intend to speak for a long time. I know that Bill C-21, particularly the issue around ghost guns, is something that law enforcement wants to take immediate action on. So we need to move forward in a forthright manner. I have a motion that was circulated to committee that for the purposes of today's meeting, that the committee extend its meeting of May 9th, 2023 until midnight for clause-by-clause consideration of Bill C-21. Now, Mr. Chair, I heard yesterday in the House something that I felt was profound disinformation that was said by the Conservative public safety critic, that almost half of the amendments had been considered at committee, and that's simply false. As you know, Mr. Chair, we've considered, since we started again, 12 amendments out of 151. So you can do the math as I have, Mr. Chair. I note that at this rate, we simply would not have this bill back to the House for months and months and months. Why is it urgent? Well, we know because of the delays, and these delays were caused by what I felt were Liberals' misplaced amendments that were done without consultation. Now we have the Conservatives filibustering, so they're also causing a delay. But during that time, Mr. Chair, we've seen an exponential increase in the use of illegal, untraceable ghost guns across this country. And so the House is seized by an expansion of scope, which will be important. But we need to provide law enforcement with the tools. We need to be targeting criminals. And because the withdrawal of the amendments mean that what would be targeted by this Bill C-21 is criminals, not law-abiding gun owners. It's important that we move in a forthright way. I've been raising this issue, as you know, Mr. Chair, now for a couple of weeks to vastly expand the number of hours. The committee has the ability to do that, and I'm proposing that we do just that for the purposes of today's meeting, to meet until midnight. And I hope that we can come to a consensus rapidly on this. I don't intend to draw it out if there are members who are opposed, but I do believe it's an important step that we need to take for public safety. We need to move this bill forward, and we can't do that if it continues to be stuck in the committee. Alors, Monsieur le Président, étant donné que ça...
So, Chair, as it's taken so much time just to deal with the first few amendments, it's important to give us more time for the consideration of each clause in this bill. So I really hope that we will reach consensus around the table about the importance of C-21 to fight against this threat of ghost guns and also the importance to get this bill adopted and complete this study, because it's been taking a great time to get through this. That's why I've put forward this motion today.
Thank you, Mr. Julian. Madame Michaud, allez-y, s'il vous plaît.
Merci, Monsieur.
Thank you, Chair. I'd just like to mention something. The motion in French is just one sentence, and there's a typo. There's an English word, and then there's two words that are repeated. I know that Mr. Julian's French is very good, so perhaps he could have taken time to draft this correctly in French. Unfortunately, that's not the case today. So before we debate this motion, I'd like to know, do we have the necessary resources in the chamber to do this? I don't mind sitting to 12, but we've got officials, technicians, interpreters. So do we have the House resources to allow us to vote in favour of this motion? Perhaps the clerk could let us know on the resources side.
Il suffit de...
Well, perhaps we could do the motion orally.
Motion orally, it would be adequate because that's generally acceptable for motions, particularly shorter motions, and then you will get the interpretation. However, I will ask the clerk if it is possible to also send the motion in complete French. Mr. Noor Mohammed, followed by Mr.
Point d'ordre,
she was
Monsieur le
asking-
Président.
Point of order, please. It was a comment in passing, but my question was really whether we have the resources in the House to continue to midnight this evening. Could the clerk let us know if these resources are available? As I said, I don't mind being here until midnight. I'm sure it's the same thing for my colleagues, but there's officials, interpreters, technicians. So is it really possible to sit until midnight as requested in the motion?
Sorry, I misunderstood your question earlier. We have made the request for resources, and it is at this time denied. However, if we pass this motion, it will be we will send it back to the administration, and they will get with the whips to decide whether or not they want to cancel sufficient resources in order for us to proceed. So we can pass this if it is the will to the committee to do so. It doesn't mean that we will be able to sit until midnight, but we will rely on the House whips to decide that. Fair enough. Did you need still need the motion moved orally? No, c'est bon. Monsieur?
It's okay.
Merci, Monsieur le Président.
Thank you, and good morning, or rather good afternoon, everyone. The point that's been made by the Bloc Québécois is very good. It's one sentence and it's still not correct. So could that perhaps be read out in French correctly by respect for the official languages? Could that be read out in French correctly?
I will ask Mr. Julian to do so, and then we're a little bit out of sequence, so I think after Mr. Julian, we'll go back to Mr. Noor Mohammed, Mr. Shipley, and then Mr. Motz, I believe.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. There is an English word that slipped into the French version. Madame Michaud and Mr. Ouz are quite right about that error. And I'm got a great deal of pride in my French, and I've often corrected texts from the Bloc Québécois and Conservatives where there were errors in the French text. So I feel very uneasy to see that there's an error in this motion, but we just need to remove that word and say
Jusqu'à minuit pour faire l'étude article par article du projet de loi C-21.
thus the committee extend its meeting on May 9th until midnight for clause-by-clause consideration of Bill C-21. So that was the corrected version read out in correct French.
The clerk has advised me that the error happened in the clerk's office, not his office necessarily, but in the clerk's office. We'll go now to Mr. Noor Mohammed, please. You're good? Okay. Mr. Shipley.
Just quickly, I just have to make a comment here. Thank you, Chair. I'm just a little bit confused, which is easily done. I'm not sure, we seem to be putting the proverbial cart before the horse again. We're going to sit here right now. To me, and I'm all good to sit here till midnight. I got nowhere to go. I'll stay all you want. Looking forward to it. Love spending, no, tomorrow night's the Leaf game, so we got all kinds of time tonight. Love spending time with my colleagues into the evening, no issue. But we're sitting here now, we're talking about trying to get through this bill C-21. But right now, we're talking about a motion that you just mentioned or said we don't have resources for. Why are we doing things backwards again? Why aren't we just jumping into C-21 and getting through this? What is the point of debating a motion that we don't have resources for? Maybe the chair could illuminate me on that.
Well, at this moment, we don't have resources for it, but if we pass the motion, it could be that we will. But that will be up to the whips.
Yeah, okay, I understand that. But this is, again, the parliamentary procedure is not always my strongest point in this. We have people who can do that type of thing. This is kind of how we got here in the first place, by dropping amendments at last minute that weren't reviewed properly. This has happened a couple times now as far as the Conservatives are concerned. It's happened a couple times now with major amendments. And now we're getting one today, a motion that, again, really, in all likelihood, it might happen, it might not, but we're sitting here wasting time again. We could be on C-21 talking about whether we're going to go again. I'm just getting tired of putting the cart before the horse. You know, I'm here to do work. I'm here to do what people elected us to do, and that is to pass good legislation. But I just, once again, I'm a little frustrated, and I want to voice that concern, Chair.
Oh, thank you for your interjection. And this motion was, of course, properly notified to the committee and so forth. I have next Mr. Motz. Mr. Motz?
Keep my hand off it. Every time I push it, he shuts it off. So
Okay.
I think it's a conspiracy. Thank you very much, Chair. I find it interesting as well that, as my colleague Mr. Shipley indicated, you know, the resources tonight are difficult. We are sitting in the House until midnight. There are other committees that are sitting as well late, and so I find it astounding that we would even consider a motion that that we don't even know whether it's going to be possible to sit past our 6:30 time slot. In any event, why do we find it? Why is it necessary to be in the spot that we're in? Why did Mr. Julian feel it necessary to put a motion forward? I just want to reiterate and correct his assertion that we're not halfway through. If you look at the amendments that are before us, there are 25 of them that add a word, firearm part, in 25 of the clauses coming forward. I don't see that taking 20 meetings. So let's actually talk about the meetings. So on January 31st, there was no meeting. And no good reason was given because we didn't have a meeting. We know now why there wasn't. But February 3rd, that's the meeting that we had where the amendments were withdrawn, right? So we know why we didn't have a meeting on January 31st. On February 7th, we did a Russian study, not C-21.
Point of order.
Mr. Julian on the point of order.
Thank you, Mr. Chair. Since the Conservatives are obviously filibustering this motion, as I signaled earlier, I intend to withdraw it if the Conservatives are going to be blocking this again, as they have over the last 2 weeks. It doesn't make sense just to encourage another filibuster on top of the filibuster they've already been engaged in.
Well, thank you, Chair. I think it's incredible that the member would talk about us filibustering, and if you actually looked at the time taken by members opposite and Mr. Julian, you'll see that they have taken the majority of time to filibuster themselves. So I find that rather rather rich. Anyway, I will continue unless Mr. Julian wishes to actually withdraw his motion.
I believe that is the intent, although he can't actually make a motion to do so because we engaged in this motion. But if there is no objection, I think we require unanimous consent to withdraw the motion. So if there is no objection, we can consider the matter withdrawn. Is there any objection to Mr. Julian withdrawing his motion? Seeing none, thank you, Mr. Julian. The motion is withdrawn. We will therefore carry on with clause by clause on C21. We left off last meeting at the end of clause 2. So we are starting clause 3. And first up is Mr. Nur Mohammed with G11. Please go ahead, sir.
Thank you, Mr. Chair. And not much to say on this other than just to note a couple of things. One is these are the G11, of course, will now look specifically at the matters related to how we address the problem of ghost guns that I know every single member of this committee is concerned about. We've heard from police forces across the country. In my own community of Vancouver, the VPD have been very, very keen that we act, and we act decisively. The reason that we need to get moving on this entire piece of legislation, as my friend opposite noted, is so that the police services have the resources that they need to get these types of guns off the streets and keep our communities safer. So I hope that all members will support this amendment and others that are related specifically to it. Thank you, Mr. Chair.
Thank you, Mr. Nur Mohammed. Is there any discussion? Seeing none, all in favor? I'm sorry? Mr. Motz, followed by Madame Michaud. Okay. Sorry, perhaps I'm confused. Was there any
What in the Act? So all the underlined in G11 is replacing 109.6? Or 109.1B, I mean? I didn't bring my criminal code, so I don't have the, yes.
I can answer that for the committee.
Thank you.
Thank
Do you
you.
have a criminal code that I can borrow, by the way?
I do, and it's 2023. It's
Oh,
not 2021
perfect.
as
Thank you.
opposed to the last ones I've brought. So this motion would add the 2 new computer data offenses to Section 109 of the Criminal Code, which is the mandatory prohibition order. So it just adds it to the list of offenses in paragraph B, for which a mandatory order must be made following conviction of one of these offenses. And the order can be made between 10 years to life, depending on if it's a first offense or second.
further intervention, or do you wish half a minute to have a look at that?
Confirm something here, Chair, if I may, please. They've added making.
So it's adding section 102.1 sub 1 and 102.1 sub 2. Those are the new computer data offenses that have already been moved and carried.
Right.
In
Right. Okay, so now does this change, does it impact, this is just the manufacturer, ghost guns, obviously, but does this actually include the parts required?
So that is a related motion, and I think we
Right,
can
that's
speak to
coming.
that. It's coming.
Right, okay. All right, thank you. Thank you.
Motz, Monsieur Paulus, allez-y, s'il vous plaît.
Merci.
Thank you very much. Just to clarify, on B85(2), because we understand the purpose of the ghost guns, the ones that are manufactured, which are operational, which can be discharged. But here, when we're talking about an imitation firearm, is it a toy? It's not operational, it's imitation. So could you clarify that for me, please?
Yes, so we're not talking in this case about imitation firearms. We're talking about bullet-firing firearms. So the computer data offenses involve only firearms, which can cause serious bodily injury or death under Section 2 of the Criminal Code. So what this motion would do is bring the two new computer data offenses, which is possessing computer data for the purpose of making a firearm, or manufacturing, or sorry, the second is sub 2, which is distributing 3D printers, right, and adding it into 109.
Can I ask another question?
Oui? Yes?
So can the officials tell me then, is there any provision that having a possession of computer data for the purpose of making a firearm, is there any possibility or any provision for the allowance of that? Or just the simple possession now becomes an offense, period? Is that what you're saying?
So no, that's not what I'm saying. What I'm saying is the two new offenses
Yes.
that were added to the criminal code and carried at the last meeting through a motion, I don't have the number in front of me, 3.1. No, it's not 3.1. Those two new offenses, which is possession for the purpose of manufacturing and distributing, knowing that it will be used for or will be trafficked, those two offenses are being added here. So those two offenses were already carried, and they are being added to the mandatory prohibition order provisions, which are mandatory upon conviction of these offenses. G8.
Pardon me?
thanks.
Okay. I wasn't here last meeting, so thank you.
Any further discussion? All in favor of this amendment? Opposed? On division? Okay. Shall Clause 3 carry? All in favor? I'm sorry, was that on division? Shall Clause 3 carry? All in favor? I'm sorry, did you say on division? Yeah, I'm going to ask you to say it louder so I can tell. Okay, on division, we carried. This brings us to new clause 3.1, Amendment G12, which I believe stands in the name of Mr. Nur Mohammed.
Thank you, Mr. Chair. And now this amendment deals specifically with the issue of firearm parts, which is underlined there. And again, within the same spirit of the manufacture of ghost guns at home.
Seeing none, all in favor? Opposed? Carried. This brings us to G13, also in the name of Mr. Nur Mohammed. Please go ahead.
Thank you. Again, Mr. Chair, this again specifically deals with discretionary prohibition orders and adds the words firearm parts again.
Any discussion? Seeing none, all in favor? Opposed? Carried. So that, do we have to, so this is a new clause 3.1, do we have to carry it? No. No, okay, good. Yes? I'm sorry? Oh, the bells. Okay, so we require unanimous consent to carry on. Do we have consent to sit for a few more minutes, or do we just adjourn or suspend until after the vote? Suspend. Okay. I'm sorry? Oh, it's a 30-minute bell, but we can't carry on without unanimous consent, so. But we got through a whole clause and another clause, so. We got through 3 and 3.1. That's Thank Resumed. We are just about to start Clause 4. And in Clause 4, we have G14 in the name of Mr. Nur Mohammed. Oh, wait a minute, wait. Before we get started on Clause 4, our legislative clerk has pointed out that there are discrepancies in the documentation. The word 30th is written with a mixture of numbers and letters, and he would like us to be able to change that everywhere it occurs in the text to be fully written out, not 30. Correct. So do we have the agreement of the committee to do that? Good. C'est bon? Bon. Okay. Now we go back to Mr. Nur Mohammed to move I'm sorry? Madame Michaud, allez-y.
Oui, merci, Monsieur.
Yes, thank you, Chair. Before we go into the amendments on Clause 4, I've got a question for the legislative clerk. Can you confirm that Clause 4 and the following deal with the red flags? Can you confirm that it's Clause 4, 5, 6, 7, 8, 9, 10, and 11? Is that correct? Or the officials, if someone could confirm that for me.
Let the officials respond.
Correct, 4 to 10. 10 is the emergency weapon limitation order. So 4 is the red flag emergency weapon prohibition order, and Clause 10 up to Clause 9. And then Clause 10 is the emergency limitation on access order.
Donc, l'article 5.
So Clause 5 is also on red flags, but not Clause 1. It really is 4 to 10. Is that correct?
Correct. There are consequentials 5, 6, 7 to existing provisions, but as a result of the red flag regime.
C'est bon?
Is that okay for you?
Hey, Mr. Nur Mohammed, G14, if you please.
Thank you, Mr. Chair. And again, this deals with firearm parts and specifically ensures that the firearm parts are included in the prohibition order and, again, are tied to the previous two. So hopefully we can see support on this and keep moving.
Any discussion on G14? Seeing none, all in favor? Opposed? Carried. So we go now, I believe, to CPC 3. Standing in the name of Ms. Dancho, Mr. Motz, if you please.
Thank you, Chair. I will introduce this on behalf of Ms. Doncho. She is currently in the House. So this amendment is replacing line 31 to 36 on page 2 with the following. That a member of the immediate family of a person or persons who resides with that person or an organization authorized to submit an application on their behalf, a peace officer or a medical professional may take an ex parte application to a provincial court judge for an order prohibiting the person against whom the order is sought from possessing any firearm, crossbow, prohibited weapon, restricted weapon, prohibited device, ammunition, prohibited ammunition, or explosive substance, or all such substances if they believe on, is how that ends. Can I just have a second, Chair, please? Just a moment.
Sure, absolutely.
Chair. Thank you for your indulgence, Chair. What this amendment really does is it makes immediate family members or cohabitating persons eligible to file an ex parte on the requests, and it lowers the chance of malicious false claims. And we're trying to soften the current language that exists. Now, I guess a couple of things that I want to remind the committee from what we heard. So almost unanimously from stakeholders, we have heard that C21's proposed red flag laws or their measures are costly, ineffective, and redundant. And I want to get into some of the information that we actually heard during the study. The National Association of Women in the Law indicated that citizens or other organizations, much less potential victims, should not be expected to put themselves at risk by going to court to request action that should be immediate and within the direct responsibility of police. They went on to say that shifting the onus of enforcement to women and third parties, as C21's red flag laws actually does, or attempt to do, is a guaranteed route to increase fatalities. Actually, Miss Rathjen from Polysovio said there is not one women's group that asked for this measure. She went on to say that it is not relevant in the Canadian context. Victims of abuse can call the police, and it is up to the police to investigate, and they have all the investigative tools necessary to remove those weapons. She went on to say that the measure is dangerous and that it could allow police officers to offload responsibility onto victims. The existence of such measures will undermine reforms that need to take place when police don't necessarily or don't take cases seriously. The current system is the best system. Another lady by the name of Louise Rendo, and I don't know the group she represents because I can't say it in English. Her comment is that, can you read, what is? Regroupement des maisons d'hébergement. Oh, that one, okay. Very excellent. So we find this, she said that we find this measure not only unnecessary, but might even be counterproductive for victims. We recommend that 4, 6, 7, 8, 9, 10, 11, and 12, which introduce the red flag measures, be removed from the bill. Victims have neither the energy nor the moral strength to go to court to have weapons withdrawn in addition to all the steps to protect themselves or flee domestic violence. Wendy Cookier from the Coalition for Gun Control actually said, I would argue, and I quote, that it's the police responsibility to keep guns away. It's not private citizens' responsibility. In my view, she said, private citizens should be able to notify the police someone is at risk and expect the police to take action. Angela McDougall from the Battered Women's Support Services indicated that though the intention of the red flag is good, it does create the potential conditions where we're putting an unreasonable burden again on a victim or survivor to address their safety. When that happens, and we've discussed this a little bit so far, when we create that kind of opening where the survivor is somehow then responsible for their safety, the system then orients itself in that way and begins to question whether the victim has done everything she could do based on the interpretation. There's a lot of work to be done already in the terms of the amount of victim blaming that exists. And the red flag, although I think the intentions are solid, creates another potential loophole and a chasm in which survivors can find themselves in. Without an advocate, without understanding how to navigate the system, and then blamed if they are not following through in the ways in which the system thinks they should with respect to these measures. We heard from police agencies who deal with this. Chief McPhee from Edmonton Police Service said the red flag law is well intended. However, many of the proposed powers already exist under Section 117 of the Criminal Code. As it stands, a law would impose a significant draw on police resources should numerous applications be granted at a time when many Canadian police services are stretched thin. This could further increase service demands. Brian Silve from the National Police Federation indicated we are seeing in a number of provinces there are not enough Crown prosecutors, there are not enough judges, and there's not enough trial space. Even if we end up in a court proceeding for a red flag or yellow flag, however, that might look good, it is going to be addressed is it going to be addressed in a timely manner? If it's not addressed in a timely manner, is that person continually put at risk? The downstream impacts of this are something we need to consider. End of quote. Andre Gillineau from the police in Montreal said, when a person is in danger, the first people to call are always the police. It would take an inordinate amount of time to go before the courts to try and get a firearm license suspended. It is as proposed in these amendments, and as the courts are already overwhelmed. The problem is that people can go before the courts to explain their point of view in good faith, but the judge won't get the police officer's perspective. Police officers have information that the judge cannot access at that time. For example, the judge does not have access to data banks or to police expertise. He or she will simply have to base their decision on the person before them who has expressed their concerns. And I was really intrigued with some of the comments from our Indigenous groups who are at the committee. Terry Teegee from the British Columbia Assembly of First Nations said this: "We are very concerned with the lack of clarity with respect to red and yellow flag laws that are applicable to First Nations people, specifically on reserve and in First Nations communities. Handguns and assault-style weapons are not used for hunting. However, the provisions in C-21 will establish red and yellow flag laws and provide no guidelines for how those new laws would apply to First Nations. This is significant as it may impact possession of firearms such as long guns or rifles, which are commonly and responsibly used by First Nations for hunting purposes." Chief Heather Bear from the Federation of Sovereign Indigenous Nations indicated
Point of order,
that
Chair. The member seems to be arguing for one of his future amendments about Section 35 rights. I wonder if we could just keep, which is CPC 5, I wondered if we could just keep it to C3. Because so far all I've heard is why we should delete the clause, not why it should only be limited to a member of the immediate family.
Hear me out. The Canadian Bar Association said the provisions of red flags do not consider the hunting rights of Indigenous individuals as well. The court is not required to balance these factors.
Mr. Julian on point of order.
Yeah, Mr. Chair, I know the Conservatives are doing their best to filibuster. I know Mr. Motz is a very experienced parliamentarian. He knows that you don't speak to another amendment that is completely different from the amendment that is before us. This is a filibuster. It is designed to block passage of the bill. And tragically, Mr. Chair, as you know, law enforcement is looking for us to put forward these measures on ghost guns that are increasing exponentially across the country. So I would ask through you for the Conservatives simply to stop filibustering, stop speaking to another amendment than what is the amendment before us, stop asking questions that they rhetorically already know the answer to. We've all done our homework. We're all ready to vote. I just find it very disquieting, the Conservative filibuster, to block this legislation that is so badly needed by law enforcement.
Thank you for your intervention. I would urge Mr. Motz to, adhere close to the amendment, but go ahead.
Point d'ordre, Monsieur le Président.
Point of order, Chair. I'd just like to try and understand. Mr. Motz is using the debate on CBC 3 to talk also about Clause 4 in general. And I also have things to say about Clause 4 in general. So what's the best moment to do that? Is it during this particular amendment, or is it after we voted all the amendments on Clause 4, just before we vote on Clause 4? Is that when we should raise questions? How do we normally proceed? Could you please clarify?
Normally speak on Clause 3 when we're talking about Clause 3 and Clause 4 when we get to Clause 4. I should note that if this is CPC 3, right? So if CPC 3 passes, then CPC 4 cannot be moved due to a line conflict. Anyway, we are engaged in a debate on matters relating to Clause 4 of the bill, and I would certainly urge all members to stick to Clause 4 as much as possible. Thank you. Monsieur Motz.
Thank you, Chair, and I certainly take exception to Mr. Julian's assertions that this is a filibuster. We have heard, and you weren't here when this occurred, we heard individual witness after witness after witness try to urge the government to stay away from the red flag laws, leave them the way they are. This bill makes a mockery of them, and it actually puts victims at risk. So that's exactly
Point
why.
of order, Chair. The amendment that we're talking about is still looking at having a member of the immediate family of a person or person who resides with that person be able to go to court. So the Conservatives are not talking about deleting the clause. They're talking about limiting who can. And what they're doing is ensuring that an ex-partner of someone who abuses them or stalks them is not able to take advantage of red flags. So I think Mr. Motz needs to make up his mind. Either he wants to delete it, or he's going to talk about CPC, which is still allowing a member of the immediate family or to go to court to get the red flag. So it actually is keeping red flag in spite of what he's saying. So I know he says he's not filibustering, but he's talking about two different things. So if he wants to keep to CPC 3 and make it relevant to what we're actually debating, that would be really helpful.
Mr. Julian, on the same point of order?
Yes, thank you, Mr. Chairman. The Conservatives may be confused. They haven't done their homework on this bill, but they shouldn't be holding up the committee having not done their homework.
Interventions. I certainly would encourage all members to stick very closely to the clause we're dealing with. I'm assuming Mr. Motz will come back to that in quick order, I hope. Mr. Motz, go ahead.
Thank you. I appreciate the enlightened interventions. One of the things that I want to make it very, very clear that I will acquiesce the conversation about red flag laws because I do not support them. I have never supported them. And I'll tell you why I don't support them. I don't support them because it will cause more significant harm to those who are seeking to be safe, those who are looking for intervention. Now, the current legislation, as it is written, is pretty adamant about what needs to be done. If the red flag laws remain in this bill, which I hope that the witnesses that you all have heard will make you realize that they actually put people at risk as opposed to helping what you're trying to do. But if this bill passes, or if that portion of the bill passes, this amendment in G3 or CPC 3 is meant to soften that impact, to soften the requirements for it. While, again, like I said, I personally cannot support this, and I'll get into that at a further intervention with regards to my experience on dealing with this exact issue. And so anyway, that's all I have to say about CPC 3.
Thank you, Mr. Motz. We go now to Mr. Moff, followed by Mr. Shipley. Go ahead.
Thanks, Mr. Chair. I will comment on a couple of things that Mr. Motz spoke about. His amendment is limiting it to a member of an immediate family or a person who resides with that person. So it's severely limiting who can go to court. And while we did hear from women's organizations about red flag, I would point out that doctors came and were very supportive of it. And Halton Women's Place in my riding only has women come to their shelter who are the spouses of police officers. And so the option for them to go to the police is not an option for them. So while I recognize that the police should be doing their jobs, these women are not comfortable calling the police. So we're leaving them without any tools to be able to get that firearm taken out of the home. So I recognize that other parties are not supportive of red flag, but I would point out that there are women who are in relationships who can't rely on the police. And Mr. Mott's Indigenous women are also subject to Section 7 right to life. So I'll have more to say on that when we get to that particular amendment. Thank you, Chair.
Thank you, Mr. Moff. We're going to Mr. Shipley, followed by Mr. Julian.
Thank you, Chair, and I'll bring this up now because the member opposite just mentioned how medical professionals were in favor of that. I'd like to read a few quotes to differentiate the opinion on that a little bit, if I may. So I will note that the Canadian Association of Emergency Physicians were initially supportive of C-21's red flag laws, but as of October 21st have reversed their position completely. They do not support the current provisions and prefer a reporting mechanism for physicians. Mr. Alan Drummond of the CAEP quoted, "The problem as I see it with Canada's proposed red flag law is that it is heavy on the judiciary and court process and equally burdensome on the vulnerable for whom the process may seem intimidating and an exercise in futility." He also went on to say, "The government cannot expect the victims of intimate partner violence in a climate of fear to initiate the onerous task of court proceedings and places yet another and unwelcome barrier to those seeking safety for themselves and their families. We are supportive of the concept of red flag laws, but not this red flag law." Dr. Atul Kapoor of the CAEP quoted, "We have concerns that in its present form, the language in the bill will have very limited effectiveness. We continue to maintain that this is far from the timely responsiveness that is required in our view. We, as emergency physicians, must be able to report the incident or a patient at a higher risk to the police directly in order to protect the individual and their friends and families. When minutes and hours count, days or weeks to act is indefensible. This applies to patients who are at a high risk of suicidality, but do not reach the level of needing to be admitted to hospital. It also applies to patients with a history of dementia and impulsive behavior, and particularly to patients we identify at risk of domestic violence or interpersonal violence." Dr. Atul Kapoor also stated, "Placing the onus on them or on victims of interpersonal violence on a family member of a depressed person or a demented parent is largely unworkable and an unwelcome hindrance to getting the guns temporarily out of the home of those in crisis." The Canadian Bar Association also stated, "Some have argued that the proposed provisions are a useful suicide prevention tool. We find that the deployment of tactical teams and subjecting mentally ill people to high-stress situations with possible criminal consequences is not a suitable means of handling this issue. In fact, it poses the very real risk that mental individuals will not seek help and instead conceal issues, fearing that their doctor, psychiatrist, or any other person might seek these heavy sanctions against them." Thank you, Chair.
Go now to Mr. Julian, followed by Monsieur Paulus. Mr. Julian, please go ahead.
Well, just briefly, Mr. Chair, I mean, we have Conservatives speaking to the wrong amendment. I think we're at the point where I think the House will have to direct this committee. It's been weeks now. We've been unable to get additional committee hours. We are seeing as well the fact that Conservatives aren't speaking to the amendment, speaking to a different amendment. This kind of a filibuster, given the importance of getting the bill through, and given the importance that law enforcement has attached to the ghost guns provisions coming through, I think it's really time that the House, I know you're doing the best job you can, Mr. Chair, but the Conservatives just are wanting to stop up this bill, not wanting to bring it through, and I think that's clear to everybody who's been watching the deliberations of this committee for the last couple of weeks.
Thank you, Mr. Julian. Monsieur Paulus, allez-y, s'il vous plaît.
Please go ahead, Mr. Paulus. Thank you, Chair. I think that the work of the Conservative Party is quite tangible with the amendments put forward to improve things. And what's most fascinating, and I'm not a permanent member of this committee, but I've been following your work, and it seems there's a group of that protect victims that have clearly identified that there's a real issue with this red flag system. So I don't know why we're maintaining the position to fight against our proposals. Now you'll remember Ms. Rajan, who said that this really doesn't work, and the Regroupement d'Hébergement said the same thing, etc., etc. So at some point in time, we have to try and see if we can change things, change amendments that are not working. And according to victims, we're talking about the Conservatives, but we're here to defend victims. So it's strange that we have to fight against the Liberal government, because often we present the opposite. But we are here. We've listened to victims' groups. And I meet with the groups with my own bill, and victims always have this burden. That's why it's not working here. We want to change this. My colleague from the NDP, I don't think we're wasting our time. This is a fundamental point when we're talking about victims. They're the first people who should be taken into account with this bill, but it seems we're doing the opposite. We're just sweeping aside what the victims have said. That's why we're working on these amendments to improve things, but it seems that people are not very receptive here.
Mr. Shipley, followed by Ms. DeMoff, followed by Mr. Motz. Mr. Shipley, go ahead.
Chair, I have to make an interjection as to what Mr. Julian last addressed after my speaking. To my honourable colleague, the member across from me, Ms. Damoff, brought up that doctors were supportive of it. And you didn't say a word, not a word. I have some information in front of me. As you mentioned, we haven't done our research, but I obviously beg to differ, that where I mentioned 4 or 5 paragraphs that proved that doctors were against it. You took great offense to what I'm saying. Sir, I will look you in the eyes every now. I'm not filibustering. I'm trying to do my job.
Please speak to the chair.
Mr. Chair, I will assume you. I am not filibustering. We have a job to do. We've been elected to do this. I could sit here right now and talk about this all day, but I'm not going to. But I'm just sick and tired of every time we're saying something, Mr. Julian defending the Liberals on their side, and they were saying actually the opposite, but we're debating. That's what we're here to do. It was fine when Ms. Damoff brought up with the medical doctors, and there was no issue there. Our side's trying to counter that, and it's a big problem. So I take offense, Chair, to what was said last time after I finished. I just wanted to get that off my chest, and we can carry on. But I am not filibustering. I'm trying to prove some points and do my job.
Thank you, Mr. Shipley. I think we have Mr. Moff and then Mr. Motz.
So I'll go back to the fact that the Conservatives have still not talked about CPC 3, which is the motion in front of us. Perhaps they should have moved to delete the whole clause, because that's what they seem to be debating. CPC 3 is saying that only an immediate family member or someone who resides with a person is able to go and get a court order. So I wonder if the Conservatives could explain to the committee in CPC 3 why they feel that only immediate family members should be eligible and not, for example, a woman whose ex-partner is stalking and threatening them. This is the amendment that we have before us. The Conservatives haven't put forward a motion to delete Clause 4. That's all they've talked about. The motion says it's only an immediate family member. So could they perhaps speak to their motion and explain to the committee why someone who is no longer living with an individual who continues to harass and stalk and threaten them should not be part of the bill?
Mr. Motz, you're up next, if you wish.
Thank you, Chair. I will take the first part of this intervention to address Mr. Julian. You know, this committee waited 6.5 weeks. Your assertion that we are filibustering is rather actually offensive. As Mr. Shipley says, we have a job to do. Your party, your real members, probably won't be here next time around if this comes through and is voted through as it is right now. That's the reality. That's what we're hearing from NDP ridings across this country and rural ridings. So if that's the route you want to take and act as the Liberal House leader, then you go ahead and do that. It'll be at your own demise.
However, if you will.
So 6.5 weeks, 9 meetings were missed on this committee. So if the Liberals are saying, or the NDP is suggesting that it's now the Conservatives who've held this up, you weren't here, you didn't see what didn't happen, and how we waited and waited
Through the chair,
for this to happen.
Please.
So getting back to CPC 3, I think it would be important to recognize that all this is trying to do, all this amendment is trying to do, that if the red flag laws are accepted, and like I said before, I hope they are not, it will soften the approach to allow for immediate family members and cohabitating persons to apply for an ex parte request for, and really what it does is it lowers the chance for malicious claims. That's the whole idea. You haven't been out there, Pam, obviously.
Again, please direct your comments to the chair. It's best to avoid speaking directly to each other on both sides. So is your intervention done? Yes. Mr. Julian, you're up.
And thank you, Mr. Chair. Well, it's very clear when you speak to a different clause than the clause before the committee, it's a filibuster. When you're asking questions that you've already had the answer to, it's a filibuster. When you're asking questions that are repetitive in nature, it's a filibuster. So yes, the Conservatives have been filibustering this for a number of weeks, and I have continually raised the possibility that we extend hours to get through this. And Conservatives have refused each time. So yes, it is absolutely a filibuster. You may not like the fact that I'm calling you out, calling Conservatives out on it, Mr. Chair, but they may not like that. But it is true that they've been filibustering, and they're filibustering legislation that is important, not just on ghost guns, things that need to be moved forward. Law enforcement has said this is vital that we take action. Mr. Motz, I would agree with him on the issue of the Liberals making a huge error back at the end of the year, which delayed the committee for a number of months. But the Conservatives' actions now, to my mind, bring the old adage, two wrongs don't make a right. And that's what we're seeing, the Conservatives compounding the error that the Liberals made. And I just find it inappropriate. We are on CPC 3. Conservatives have not spoken to it at all. They seem to be speaking about everything but CPC 3. And I would say through you, Mr. Chair, that there's an issue of relevance to add to the filibuster. I find we need to move forward, and the House can make a decision to direct this committee, and I certainly hope it does. Parce que la Chambre des communes a une responsabilité.
Because the House of Commons has a responsibility to direct a committee that's no longer working, and the filibuster of the Conservatives means that we cannot get through this bill.
Point de règlement.
Point of order. I don't know if Mr. Julian realises that every time he's taking the floor to say that the Conservatives are trying to drag out the debate, he's also slowing down the debate. So, Chair, could we please get back to CPC 3 and debate this CPC 3?
Monsieur Julien.
Thank you. Please go ahead, Mr. Julian. So on CPC 3, I'm going to vote no on this, as I've already mentioned, and I hope that the bloc will join the other parties so that the committee can be directed that Bill C-21 will no longer be held up.
Julian, and I certainly take Madame Michaud's point that the more we talk about whether we're in a filibuster, the more we're in a filibuster. So, Mr. Motz, it's over to you, please.
Thank you, Chair. Can we call a vote, recorded vote, please?
Seeing none, Mr. Clerk, if you would call the vote, please.
Ms. Damoff.
No. No.
Mr. Gair.
No.
Mr. No Mohammed.
Nope.
Mr. Shifke.
Nope.
Monsieur Paulus.
Yes.
Monsieur Gourde.
Favor.
Yes. Mr. Shibley.
Yes.
Madame Michaud.
Against.
No, contre.
Against.
4 en faveur, 6 contre.
4 in favour and 6 against.
The motion is defeated.
Apologies. Mr. Chan.
Yes. No. I apologize. Can I correct that to no?
No, thank you.
I missed out on that one. Sorry.
That's why you weren't voting.
It was delicious.
Too much mercury.
Thank you all. That was a interesting debate. We carry on to CPC 4. Sorry?
CPC 4 is, we'll withdraw.
I'm sorry?
For withdrawing CPC 4?
You're withdrawing CPC 4?
And you had said that CPC 5 is redundant based on what happens in CPC 3?
Well, CPC 4 could not be moved if CPC 3 had passed. The CPC 3 did not pass. But you're withdrawing CPC 4,
Yes.
correct? Okay.
How's that for filibustering?
It's awesome.
That brings us to CPC 5.
Withdraw?
CPC 5 is withdrawn.
Yep.
Quite a filibuster, eh?
So that brings us to CPC 6. CPC 6 is also in the name of Ms. Dancho. Did you wish to?
Yes. So what this clause really is about that we're asking that after line 8 on page 3 of Bill C-21, that the following be inserted, that if the provincial court judge determines that the hearing of an application shall be in private in accordance with Section 2, the judge shall consider any background information submitted by a peace officer following any investigation relating to the person against whom the order is sought before deciding if an order should be made. And the idea here is that we want to ensure that a judge has all the relevant information, as much relevant information as possible, to support the claim of an ex parte. And of course, as we know, law enforcement has more access and investigative ability and access to resources than the courts do. So that's the reason behind this particular motion.
Is there a discussion on CPC 6? Seeing none, all in favor of CPC 6? Opposed? Opposed? Defeated. That takes us to CPC 7. Also in the name of Madame Dancho, Mr. Mott, so if you will.
This particular motion deals with adding, replacing, or deleting lines 37 on page 3 to line 5 on page 4, by deleting lines 15 to 17 on page 5, and replacing lines 34 to 37 on page 5 with the following. That 110.1 sub 3, or the warrant issued under subsection 110.1 sub 5 shall, and then subject to to any terms. So the whole idea of CPC 7 is to require a warrant to search and seize for ex parte hearings. It lowers the chance of malicious false claims. The whole idea behind this is going back to the whole red flag laws should be done away with, because this is exactly the issue that many people who spoke at this committee who are against red flag laws are suggesting will happen if we don't put some measures in there to require some due diligence on behalf of those applying ex parte.
Thank you. Any further discussion? Madame, Ms. Demoff, s'il vous plaît.
Yeah, Mr. Motz has mentioned a few times about malicious false claims, Chair. And I really do think it's unfortunate that women who complain about abuse are being tarred with a malicious false claims and the presumption that women are coming forward with all of these false claims. So we're not supporting this amendment, but I do find it quite offensive that he keeps referring to that.
What I find offensive, Mr. Chair, is the assertion that is what I'm actually saying. Obviously, somebody's not paying attention or has a preconceived bias to what it is we're trying to do. If this bill actually tries to make women safer, people who are facing domestic violence safer, then let's do that. Let's not just pay lip service to it. Let's not just do a little dance to try and make somebody happy. Let's actually try and do it, right? And the real world is there are individuals, male and female, neighbors, whoever, who actually make false claims with no evidence. So what we're saying is we need evidence to act. So we need to be responsible and judicious with our comments.
Thank you, Mr. Motz. Any further interventions? Seeing none, all in favor of Amendment CPC 7? All opposed? Defeated. That brings us to CPC 8, also in the name of Ms. Dancho. Mr. Motz, do you wish to go ahead with this?
So in this one, we're talking about Clause 4 again, by replacing lines 7 to 18 on page 4 with the following wording. Subsection 5 shall immediately make a return to the provincial court judge who issued the warrant, showing the signs or showing the things or documents, if any, seized and the date of execution of the warrant. And also in B of this, by replacing line 20 on page 4 with the following, from a person against whom the order has been obviously made. So the idea here is we know that law enforcement can already apply to conduct searches and seizure without a warrant if there are reasonable grounds to believe that that such a need is necessary. And there's no need for anonymous individuals to have this ability preemptively. That's the issue. So, this requires a bit, again, a softening of the current position so that both sides of this conversation have some assurances that the process is done fairly.
Thank you, Mr. Motz. Any further interventions? Seeing none, all in favor of CPC 8? Opposed? Defeated. That brings us to shall clause 4. Oh, I believe, Madame Michaud, you wish to speak to clause 4 in general.
Absolument.
Yes, absolutely. Thank you, Chair. The red flag measure is one that's been discussed a great deal in this committee when we heard from experts on this matter, and particularly the impact that would have in their lives. And at a first glance, it did seem to be an interesting measure to protect women. But I was very taken aback when I heard women coming before the committee and saying that it wouldn't help women more, but in fact it could actually damage them. So I'd like to read out a passage from a letter that was sent to the Minister of Public Safety by the National Association of Women in Law on the 16th of May 2022, who talks about this red flag measure, and they're saying there is no support in favour of the erosion of the responsibilities of law enforcement and other representatives of the government when it comes to implementing a Firearm Act. They need to remain responsible and accountable to make sure that firearms licences are refused and revoked when there are potential risks for women. We should not expect citizens or other organisations nor the potential victims to put themselves in danger by actually coming before the court to ask for an action would need to be immediate and should actually be directly shouldered by the police. And it's very much recognised that women have the highest danger just after the separation, during the separation. So transferring the burden of proof of application to women and third persons, as we would see in these red flag provisions being attempted in this bill, would actually guarantee that there would be an increase in the number of deaths. And they say that we support efforts to use all the mechanisms that presently exist in the system. So they are saying that there are already tools that exist for women, and as well as granting further tools, and with community support, we could then identify the risk quickly and quickly remove firearms held by these individuals who are a threat to their own safety or any other person's safety. So they're basically saying that they do not need this extra tool of the red flag measure, which has been put forward in the bill C-21, for example, with Porte-à-Pique and with the Dasman family shooting, many other cases where people were aware of threats against women. In certain cases, the police were warned, but no measures were taken. The security of women is a real concern for the government, and so the specific intervention measures need to be taken. And here we're talking about measures that already exist in general, and I won't read through all of these now, but I'd like to invite colleagues, in particular the Liberal Party, to read these concerns and recommendations that were put forward by the National Women and Law Association. And this letter was written on behalf of several other organizations that I'd like to mention, because there's institutions right across Quebec and Canada recognised institutions, and it's people who directly work with women who may be impacted. They're on the ground and they know the situation well. So I think these are the people that we need to listen to. For example, the YMCA in Toronto, the Canadian Foundation for Women, Luke's Place Support and Resource Centre, Hébergement Femmes Canada, Calgary Legal Guidance, and the women's group or shelters for women who are victims of domestic violence, and the Education Fund, and the Feminist Alliance for International Action, and the Canadian Institution for Research on Women. And this letter was endorsed by many other organizations, such as the National Women's Council of Canada and other associations, and Police se souvient. They have also pointed out that this measure could indeed be harmful towards women. So I wanted to take time to specify that that's why the Bloc Québécois is going to vote against all the clauses that are related to the red flag measure, such as Clause 4, which is the first one. So that's why I wanted to flag this question now.
Merci.
Thank you very much for that.
Further interventions, Mr. Moff, please. Oh, sorry. It was Mr. Motz, followed by Mr. Paulus, followed by Mr. Moff.
Thank you very much, Chair. Being we're talking about Clause 4, with Mr. Julian's indulgence, I will continue to talk about why red flag laws are a problem based on the testimony we heard at committee. The Canadian Bar Association have said, and I quote, "Some have argued that the proposed provisions are a useful suicide prevention tool. We find that the deployment of tactical teams and subjecting mentally ill people to high-stress situations with possible criminal consequence is not a suitable means of handling this issue. In fact, it poses the very real risk that mentally ill individuals will not seek help and instead conceal issues, fearing that their doctor, psychiatrist, or any other person might seek these heavy sanctions against them." Defense lawyer Mr. Friedman said the following: "The concern is that the courts will be flooded with people with complaints that have been investigated by the police and found to be meritless. We don't need more backlog in our courts when the police are already taking extensive enforcement action on firearms and public firearms safety concerns." He went on to suggest that access to justice is an enormous problem right now. We are waiting 12 to 18 months for a trial in court. By cutting out the screening mechanism of police investigation, we're essentially inviting people to flood the courts. They're almost all going to be self-represented individuals, which pose all sorts of other challenges. They should be going to the police. He went on to say that we're basically creating a funnel such that the only people who are going to access that resource are people who have been denied by the police. They've been denied by the police because the police take their job seriously. In almost 15 years of practice, I've never seen that. I've seen far more overzealous police enforcement than absolutely non-reactive. The Canadian Bar Association also added another couple quotes. Section 110.2 sub 1 is particularly worrisome because of the criminal charges that arise from a Section 10.1 weapons prohibition order. It is unclear how a Section 110.2 sub 1 order denying access to information would apply with the Crown's disclosure obligation in R versus Stinchcombe. 2, if criminal charges are laid against the subject of a Section 110.1 weapons prohibition, Section 110.2 sub 1 as written will make it ripe for charter litigation surrounding an accused's right to a fair trial and full answer in defense. They also say police officers themselves are vulnerable to false complaints under these provisions. An aggrieved individual who is arrested can present a one-sided account of the interaction in court. There is no cross-examination or any ability to check records. Their identity can be sealed, preventing a further investigation. Under the current law, the initial seizure result is the revocation of licenses, which allows police or the military to continue to perform duties until they respond to the allegations. The new provisions would result in a firearm prohibition that removes the officer from active duty. That's the Canadian Bar Association. And two last ones. Firearms expert Tony Bernardo from the CSAAA, or CS Canadian Sports Shooters Association, says the following: we've been living with red flag laws for 25 years now. This is not new. This is an enhancement of existing laws. For 25 years now, if someone were to make a complaint that they were being threatened with a firearm, the police would have the ability to come right that minute and remove the firearm. That is Bill C-68 in the Firearms Act, and that's been around for a long time. A.J. Somerset, author of Arms and the Culture of the Credo, he put it this way: if this is viewed as being a way of protecting people who are at risk, women in abusive relationships, for example, I think it's asking a lot of those people to figure out how to go to court, how to make this application, how to make sure that application gets quickly heard. Mr. Chair, it is abundantly obvious to me that these red flag provisions create more harm than they do good for those who we are trying to protect, who are vulnerable and face domestic violence situations. I will tell you from firsthand experience, from actually doing these investigations for many years, that when police receive a complaint that there is a domestic violence situation, that situation, especially over the last 15 years plus, have been taken extremely seriously. There is immediate response. There is a fulsome investigation. There is authorities to seize firearms immediately, to hold those firearms, to take statements from witnesses, to put the accused in custody if there is evidence, and have them before the courts on a bail hearing. Those provisions don't exist on these red flag laws. They actually create an opportunity for the abuser to continue to abuse, for confusion with the victim, and I'm astounded by what I see here are really a failed attempt to actually make a difference. So if a neighbor calls the police, currently, we respond to domestic assaults. If a spouse or anybody else calls and believe that a person is in imminent danger, for example, we determine whether there's firearms in the residence. We determine the safety risk. We involve our victim services unit. We involve whatever resources we need to ensure the safety of this victim and then the proper dealing with the accused. And the ability to report a spousal or public safety concern with a firearm has existed since the Firearms Act was passed into law in 1995. So currently, with the current legislation outside of what is trying to be done here with C-21, or with this new C-21, there are currently 4 escalating options that exist in law. Under the Firearms Act, the Chief Firearms Officer can give notice to revoke a license. The person may continue to keep firearms while disputing the revocation in court. This is a revocation of a license, not a prohibition order. Number 2, a police officer or CFO can apply to provincial court for a prohibition order if he or she believes on reasonable grounds that it is not in the best interest of safety. Notice is given, and the firearm owner can provide evidence and contest the order at a hearing. Number 3, a police officer may seek a warrant for search and seizure that can be done without notice, but it also cancels the firearms license, and there is no prohibition until after a full hearing. And number 4, in pressing circumstances, as I said previously, police have the authority to go straight to seizing a firearm if they deem it is in the best interest of public safety to do so, like ongoing domestic assault, suicide attempt, or etc. There is no firearms prohibition until the court hearing. If the police do this improperly, they must go back through the warrant process. Now, what we heard at committee from witnesses was This provision gives ordinary citizens in this country extraordinary powers to cause search and seizure of legal owner's property with an act first, ask questions later. And as we heard at committee, this is rife with opportunities for abuse. As I said, police have authority to confiscate firearms on public safety grounds and can do so efficiently through existing legislation. We know that the courts are currently extremely backlogged, and the prohibition orders that remove firearms without notice or dispute may potentially have grave impacts on military or on police if it's not followed according to the existing law. As I've said, the goal of any legislation, specifically around C-21, should be about the protection of Canadians, about public safety. And if we have a provision that is absolutely contrary to what the bill's supposed intention is, then why are we continuing to push it? It would be, I would suggest that the government should consider absolutely removing this clause, and that would be, I can't support it, I won't support it, but the government should be looking at removing clause, anything to do with red flag laws, completely from this bill. We have heard from countless witnesses, and I've only mentioned a few, and read their testimony at this committee that says, please stop. You're putting the people we work with, people in our communities, at risk by continuing to pursue red flag laws in this legislation. Stop it. And so with that, I would say that we need to do just that. We need to listen to the experts we had here in committee and actually defeat this clause from this bill. Thank you.
Point of order? On a point of order, Mr. Julian.
Thanks, Mr. Chair. There's only 1 minute left in this committee meeting. So a little bit like Charlie Brown with the football, I'm going to try one more time and ask for unanimous consent that we extend the committee meeting till midnight tonight.
Do we have unanimous consent for this proposal? We do not. I should point out, I should have done so earlier, that we can go until 7. We have a hard stop at 7. Is it the will of the committee to do so? We don't require unanimous consent to do so, but certainly in light that we've had delays due to votes and so forth, and delays starting, it is the inclination of the chair to carry on till a hard stop at 7. And if there's no strong objection to that, we'll go now to Monsieur Paulus on this amendment or this clause.
Merci.
Thank you, Chair. In the debate on Bill C-21, it's all very political. There's lots of accusations about misinformation from both sides. But now when we're talking about the red flag provision, there's something that's quite clear. We're talking about facts here. We've got facts. And first of all, I'd like to say that I agree with my colleague, Ms. Michaud, from the Bloc Québécois on the same basic premises around the red flag provision. First of all, we thought it would be a good thing, as she said, but now it's quite clear that in terms of victims groups, this does not work, not at all. So I'm perhaps repeating a little bit what my colleague has said, but I'd like to say this in French, such as the National Association of Women and Law. And Police se souvient, we know they have an important role to play in the debate, and they've said, please do not do this. They were quite clear. They said, Liberals, don't go for a red flag provision. It's not good for women. It's not good for victims. Louise Rindeau, regroupement des hébergements, the shelters, if people know what they're talking about, it's, of course, people who are dealing with victims and women who are afraid on a daily basis, and they're saying to the committee not to do this. And I'd like to say that we're not filibustering, we're making important points, because with C-21 we're talking about firearms and rules that relate directly to victims, and Liberals are pushing these forward, and we don't know why. Certainly between the Bloc and myself, we're saying that these provisions do not work because the victims groups have clearly spoken out on this. and also the police corps that have to apply these provisions, who deal with women who call up, who have problems and who are afraid. They also have said it doesn't work. Indigenous groups have also said, I think we listened to them. I remember when I was in the committee back here, C71, the Liberals didn't want to talk about transfer of firearms from Indigenous groups, but the Indigenous groups were invited by me and they said it didn't work. That should be one of the objectives of the committee on these bills that are so essential for public safety. And Ms. Damoff said, of course, physicians agree. Well, I think that's strange because, yes, at the beginning, the Association of Emergency Physicians agreed, but after scrutiny and after verification, they completely turned around and said on the 21st of October they could no longer support this. It's not working, and they gave their reasons for that as well. So I'm finding it hard to understand why the Liberals are digging in their heels with their position. We have to recall that we're not talking about firearms, because I know that you like to do marketing around firearms, but here we're talking about the protection of victims and their relationships with their spouses. And everyone is saying, don't do this, it's dangerous for victims. So why are Liberals sticking to their position to go ahead with this? As I've said, the basic premise I thought was it was sensible and it was working, but now we've seen it's not working, so why should we not stop it? And that is why my colleague Glenn has said we cannot support this and we will have to vote against this clause. Thank you.
Merci, monsieur.
Thank you very much, sir.
To Ms. Damoff, please go ahead.
Thanks, Mr. Chair. And just before I start, I wondered if officials could tell us what sections we're losing if we delete red flag.
Hi, yes. I'd like to clarify my earlier testimony and apologize to the committee. It's clauses 4 to 11 that would include both the emergency weapon prohibition order and the emergency limitation on access order. So clauses 4 to 11.
Thank you. So thank you, Chair. I recognize that the other parties are not supporting this provision in the bill, but I actually hope that Conservatives will listen to all of the same groups that they quoted here today, like Police du Souvien and Coalition for Gun Control and Dr. Alan Drummond, as we're dealing with other parts of the bill, because they've selectively pulled quotes from them. Halton Women's Place sent a letter to this committee in support of red flag provisions. The Doctors for Protection from Guns also sent information and appeared at committee in support of it. So there is a difference of opinion on it. I remain of the belief that this would be one more tool in the toolbox that would be available to doctors and also to women who are unable to go to the police. The Doctors for Protection from Guns said, we support the proposed red flag law. Family members, physicians, and concerned individuals must have access to an efficient process to quickly have firearms removed from someone who may be at risk to themselves and others. In Canada, suicide accounts for 75% of gun deaths. A gun in the home increases adolescent suicide rates by 3-fold to 4-fold. Evidence from other jurisdictions shows that red flag laws are effective in reducing firearm suicides. Most people who survive a suicide attempt do not go on to die by suicide. This is why restricting access to lethal means saves lives. Suicide attempts with a gun are almost uniformly fatal, and that was from Dr. Namja Ahmed. So I am disappointed, and I appreciate the comments that were made about women's groups, and I've met with them multiple times on this provision, and we've agreed to disagree, but we are taking a tool away from women like those that go to Halton Women's Place who are living with police officers who are using their firearms to threaten them. So anyway, Chair, I'll leave it at that. Thanks.
Thank you, Ms. Damoff. We'll go now to Mr. Shipley.
They hit it, so we're hitting it today. Sorry about that. I wasn't trying to. I'm all nervous now. Every time I stall for a second, I think I'm going to get chastised. But I thank you for the member opposite for your passionate words, and I hear what you're saying, Ms. Damoff. But we've sat through here, holy smokes, I'd like to know how many meetings and hours total, Chair. It's been a lot. And yes, you mentioned a couple groups, Ms. Damoff, who were supportive, but we have pages and pages and heard testimony that almost unanimously from stakeholders that feel like the red flag measures are going to be costly, ineffective, and redundant. I do have to rely on my good colleague, Mr. Motz, who's been in policing for 35 years himself, and I'm sure Mr. Chang has a lot of more information and expertise on this than I certainly do, or quite frankly, maybe a lot of people around this table. I can't speak for everybody. But, we have to rely on them, and we have to make our best decisions on the information that we've been given. If we don't listen to the witnesses that come in and speak to us, then what really are we doing, and why are we bothering bringing them in? Under Section 117 of the Criminal Code, police services have the authority to act immediately with or without a warrant when there's a genuine concern to public safety. The police currently have the power to seek a warrant to seize firearms in several circumstances. These powers are currently sufficient and preferable. Red flag measures lead to secret hearings and complaints where the complainant is prevented to mounting a defense and afterwards is barred from seeking access to information related to the prohibition order. Canada's court system is already significantly under-resourced and backlogged. This measure is ineffective in an emergency because the process of going before a judge to get a prohibition order as proposed in C-21 will take at least a day, if not a lot longer in some areas. Red flag measures are likely to lead to significant charter litigation surrounding an accused's rights to a fair trial and full answer in defense. So all we can do, Chair, is make our best decisions, and I won't be supporting this today. I do feel this is going to hinder going forward. I think what's on the books currently is a better option, and that's just from what I've heard from all the witnesses, and I said from some of the experts that I'm here with. So I can't support this today, and I'll leave it to the rest of my colleagues to listen to what their words are. Thank you.
Thank you, Mr. Shipley. I see no more. Are there any more interventions? Seeing none, I'll ask for a recorded vote. Mr. Clerk, if you would, please.
Ms. Damoff. Yes. Mr. Chiang.
Yes. Thank you, Mr. Clerk.
Mr. Gair.
Yes.
Mr. Noor Mohamed.
Yes.
Monsieur Chifke.
Oui.
Monsieur Paulus.
No.
Monsieur Gourde.
No.
Monsieur Motz.
No.
Mr. Shipley.
No.
Monsieur Simard. Mr. Julian.
Oui.
6-4, 5 against.
Thank you all. I should have mentioned that the question was, shall Clause 4 carry as amended? Anyway, I believe it has carried, and all those other amendments that we did, G14, for example, was amendment to Clause 4, I believe.
Oh, I'm so sorry. You're right.
Yeah. Anyway, carried. Thank you all.
All right.
So it is, I think maybe we can get through Clause 5, maybe. So let us go to G15, which arrives next, and that is in the name of Mr. Noor Mohamed.
Thank you, Mr. Chair. Look, as I've said before, we have a series of amendments here that deal with ghost guns. This is another amendment that deals with the firearm parts, and this, of course, as we all know, at this committee, is an important element in making sure that we get ghost guns off the streets to make it harder and harder for folks to manufacture these guns that are being used in crimes. I know we have widespread support for this, and again, this amendment deals with that, so I'm hopeful that we'll have unanimous support to move forward. Thank you.
Are any further interventions on G15? Mr. Motz, go ahead.
Thank you, Chair. I just want to understand this amendment clearly. So we are adding firearm part to in G15 specifically here. Now, is there any? That's the only thing we're adding under Section 11 of the Act, or 111 of the Act. But I mentioned before, and I've been asked about this, and I don't know the will of the committee to consider it, but if we're prohibiting, and we agree that ghost guns obviously are an issue that have to be addressed appropriately, but if we're just talking firearm parts here, I'm wondering whether that it's illegal to have a firearm part. We should be adding something in there about unless you have a PAL or an RPAL, right? That there should always be that provision available there because someone who has a PAL or an RPAL is allowed to have those firearm parts in the right circumstance for the right firearm, unless I'm mistaken. I don't think I am on this issue.
Maybe I can try to answer that. So normally that's the case because possession absent a license would otherwise be an offense,
Right.
let's say in the case of a firearm.
Right.
I think if you look at the motions package, and this is why this is an important question, if you look at the motions package or in the bill, nothing would make possession of a part without a license an offense. So that criminalization that is, or rather, the prohibition created in the code and then the permission that's granted in the Firearms Act via a license, that applies to firearms. That system won't apply to parts. So what I think you'll see in some of the other motions is that the only requirement with respect to a license for a firearm part is that the person who wishes to buy one be the holder of a valid license.
Right.
So, but possession of the part itself is not touched by either this or anything else that's proposed.
Okay, thank you.
Mr. Balous, allez-y, s'il vous plaît.
Une question pour
I have a question for our officials. I was trying to find the right term there, fonctionnaire, I believe. So with this amendment, does it take away the definition of a provincial judge? That's my question on this. And if yes, why? Why would we do this? I'll read it in English.
amendment remove the definition of a provincial judge. What's that? That's for clause 5. Yes. On y No?
I can't answer the question. I can't answer the question whether it's this clause or, so that's okay. That's okay.
It's the next one. Sorry.
Okay, so the definition of provincial court judge is being repealed from, I believe, section 112, but it's being integrated into the clauses, into the red flag regime. So it just moves the definition through the clauses. It's not being removed completely, it's being repealed and reenacted in clause 4 and 10.
Further interventions? That being the case, all in favor of Amendment G15? All in favor? All opposed on division? Okay. So carried on division. So shall clause 5 as amended carry? On division? We're okay? On division? Okay, clause 6 is a whole bunch of stuff. I'm inclined to call it a night, and it's a good place to stop. So, Mr. Julian.
I'm just going to try one more time, Mr. Chair. We've done 5 clauses out of 73. I think it's fair to say we're not making progress in the way that Canadians expect of us. So I would move for unanimous consent to extend this meeting till midnight.
Thank you, Mr. Julian. I admire your persistence. Do we have unanimous consent to extend this meeting until midnight? Well, it requires majority consent to adjourn. Mr. Julian has asked for unanimous consent to carry on to midnight. Do we have unanimous consent? No, we don't. So I think a motion to adjourn has been de facto made by the chair. So I guess we'll have a vote on that to see if the will of the committee is to carry on until 10 more minutes. I'm sorry, Mr. Shipley.
I'm just curious. The member down the ways here a little bit keeps repeating himself. Is he filibustering in this meeting? I'm just trying to figure out what's going on because he keeps asking the same. Even though, sir, he keeps challenging you. You said many times we have a hard stop at 7. Many times he keeps asking to extend. I just want to know if he's filibustering this meeting.
I'll consider that a rhetorical question. So I'll...
Sorry.
Go ahead, Mr. Nurmohamed.
Mr. Chair, in the spirit of like the fact that we are sort of getting some things done and we've got 14 minutes left, was there a will to work? We have the resources till 7. Is there a will in the room to just work till at least 7 o'clock and be able to put some more miles on this and just try to do the best we can?
Sorry?
So I think we'll have to have a vote. We need a majority. So all in favor of continuing so a motion to adjourn is always in order, and we've fallen into that. So let us, all in favor of adjourning at this time, please raise their hands. All in favor of, all opposed? There we go. So we shall continue until 7. Thank you for helping me get through all that. So that being the case, we shall start on Clause 6. And we shall start with CPC 9, which again is in the name of Ms. Dancho. So Mr. Motz, do you wish to move this or someone else?
Again, this asks the question that I think asked about the removal of the a provincial court judge shall an application is the addition here on Clause 9. And we're changing it from may to shall. And I think the idea is here, it requires a judge to return firearms seized if the conditions are no longer applicable that caused them to be seized in the first place. And that's the wording change there. It puts more definitive language around the requirement of the justice.
Thank you. Is there any discussion? Ms. DeMoff?
Thanks, Chair. We won't be supporting it. We should be giving judges discretion, and I'm just going to leave it at that. We're not going to support it.
Thank you. Any further discussion? Seeing none, call the vote. All in favor of this amendment, please raise your hands. All opposed? Defeated. We go now to CPC 10. Again, in the name of Ms. Dancho. Mr. Motz, if you please.
CPC 10 adds the following, replaces lines 26 by requiring, basically it's requiring judges to return firearms if the claims made in the application are to be unfounded. It requires them to return them. It's a reasonable and due process of law. This is exactly what needs to happen.
Thank you. Any further discussion?
I'm sitting here and I see Ms. Damoff shaking her head to the common sense of that. If a complaint is found with evidence to be unfounded, there's two sides to the justice system. If a complaint is found to be unfounded, there is no evidence to support an allegation. The firearms that were seized lawfully to begin with are to be returned to that individual who is no longer the accused because there is no crime. There's nothing happened. So I think that needs to be very, very clear.
Thank you, Mr. Motz. Any further discussion? Mr. Nurmohamed.
Just on this point, perhaps officials can enlighten us. The point that Mr. Motz makes, if there is no offense or if the claim is deemed to be unfounded, does it not already provide for those? Would the issue that he has raised be one of valid concern, or is the matter then deemed to be resolved?
So I think the issue of unfounded complaints is absolutely valid, as we've seen through the testimony from victims groups, et cetera. In this, my understanding of the intent of this motion was to include the unfounded language within the revocation provision, which is far past the time a judge would look at an application as well as the evidence, the reliability of the evidence, and the applicant, and deemed that to be vexatious or unfounded at that time. So this is past that initial order that is or is not made. A decision has been made, and this allows a judge to, if an order is made, revoke it if those circumstances no longer exist. So it's a step later in the process after the application and after a judge has made an order already.
Any further interventions? Okay. Seeing none, I suggest we go to a vote on this. So all in favor of CPC 10, please raise your hands. And all opposed? Defeated. That concludes Clause 6. So shall Clause 6 carry? All in favor? On division? Okay. Look at that. Look how we're going along swiftly. Shall Clause 7 carry? All in favor? On division? Okay. Shall Clause 8 carry? On division? Shall Clause 9 carry?
On division?
On division? So that brings us, with 7 minutes to go, to new Clause 9.1. We have G16 in the name of Mr. Nur Mohammed.
Thank you, Mr. Chair. And again, here we're updating the section of the code with the words firearm part to ensure consistency and to align with the other amendments that have been passed by this committee. Again, hopefully we'll be able to move quickly through it. Thank you.
Any discussion? All in favor? All opposed? Carried. Let's call it carried. Okay, so that brings us to Clause 10. So Clause 10, we have new. We have G17, starting Clause 10. Mr. Nur Mohammed, if you please.
Again, if we look at Clause 10 now, again, here we are, it's really a coordinating amendment to add the word firearms part based on past amendments. It's, again, to provide us consistency.
Any discussion on C17, G17, sorry? Seeing none, all in favor? All opposed? Carried. That brings us to CPC 11. Withdrawn, okay. That brings us to be CPC 12. Did you wish to remove CPC 12? Withdraw that. CPC 13. So are you going to move CPC 13 or? Withdrawn, okay. That takes us to CPC 14. Do you wish to move CPC 14?
Chair, this is a lengthy one, and I certainly won't go through it, but what the intent here, by replacing some of these lines and asking to make a return to a judge who has issued the warrant. The whole idea here is to ensure that it's removing the search and seizure without a warrant on one of these on an ex parte and the consequential changes. So it lowers the chance again of those who might, for nefarious reasons, make a claim that is false.
All right, thank you. Is there any further discussion on CPC 14? Seeing none, all in favor of CPC 14?
Pardon me?
All in
Yes,
favor of
sorry.
CPC 14?
Yep.
All opposed? Defeated. That brings us to shall clause 10 carry? Recorded vote on clause 10. Mr. Clerk, if you would, please.
Ms. Damoff.
We didn't actually need it.
This
Yes.
is on CPC 14?
No, this
Sorry,
on clause 10.
sorry,
Clause
clause 10 as amended. Shall clause 10 as amended
Yes, for us,
carry?
yes.
Thank you.
Mr. Chiang.
Yes.
Yes.
Mr. Gaye.
Yes.
Mr. Noor Mohamed.
Yes.
Monsieur Chifflier.
Oui.
Monsieur Paulus.
Yeah.
Monsieur Gourde. No. Mr. Matz.
No.
Mr. Shipley.
No.
Monsieur Simard. Mr. Julian.
Oui, pour.
6 in favor, 5 against.
Clause 10 is carried.
Point of order?
Mr. Julian on point of order.
Yeah, thank you, Mr. Chair. We have 2 minutes before 7. We've completed, after a week and a half of study, 10 clauses out of 73. I think Canadians can do the math. There's still 63 clauses to go. We've had the Conservatives filibustering throughout this period. I would ask by unanimous consent that we extend this meeting until midnight. It seems to me that Canadians want us to do this work. The ghost gun provisions are needed immediately. I hope that my Conservative colleagues will finally understand the importance of doing this work. Otherwise, I think the House of Commons will have to instruct this committee. So I move by unanimous consent that we move to midnight.
Thank you, Mr. Julian. So that we have a unanimous request by unanimous consent that we extend to midnight. Anybody? Does anybody oppose this? Yes. Thank you, Mr. Julian, for your persistence and your optimism. And it being 7 o'clock, I'd like to thank our interpreters and all of our committee members, and all of the committee staff for sticking with us all this time. And thank you all. We are now adjourned.